I will start with a little history by going back to the 1980s. As stated before, divorce rates were increasing in the 1980s, and society was grasping the growing issues related to child support, beginning with the Child Support Enforcement Act of 1984. However, the act, along with other issues, did not address the problems of child support obligors being denied access to their children. Due to the growing complaints by fathers, who were the child support payers in 99% of the cases, an amendment was introduced for the revised Child Support Enforcement Act of 1988. The amendment would establish a $10 million grant for the states to set up expedited procedures to enforce court-ordered access rights. Women's groups claiming that fathers did not care about their children opposed this amendment, saying that they only wanted to abuse the mothers. They stated that fathers were not even filing motions to enforce their access rights. In support of this claim, the U.S. Department of Health and Human Services was instructed to perform a 50-state sampling of divorce cases involving children to determine to what extent a father was not remaining involved in their children's lives. The HHS received funding for an initial summary study of 5 states, with more funding once that was completed for the remainder of the country. The survey of absent parents sampled divorce case files involving children extending back 10 years. When the summary was presented to the Congressional committee overseeing the study, it was decided that no further funding would be issued. The reason? The primary results did not meet intended goals. The results showed that in 60% of the cases, the father had filed for enforcement of his access rights within 6 months of being granted them by the courts. However, despite repeated filings to enforce, within 5 years, 90% of those fathers had lost all contact of their children. Part of this was due to the legal expense, with fathers expending $2,000 for each time they saw their children. Due to the failure of the study to meet goals, the amendment to the 1988 Child Support Enforcement Act was passed. Studies in recent years have placed the rate at 40%, but as of 2001, 15% of primary residential parents are fathers. That number is continuing to grow because of a growing number of mothers deciding to ignore what society thinks of a mother without custody and choosing not to have custody of their children. Of interest on this, in 1996, Cosmopolitan magazine did a survey of their more than 1 million female subscribers on what would make them happier. One of the questions was whether in the event of a divorce involving children, would they be happier having or not having custody of them? 68% said they would be happier not having custody. Though the readership of Cosmopolitan magazine does not reflect the vast majority of middle and lower income women, it was interesting that the majority of the more educated and financially stable in our society would express this opinion. As for the amendment to the Child Support Enforcement Act of 1988, states like Kansas and Missouri partook in the grants with 2 different approaches. Kansas set up a procedure to enforce access rights through the simple filing of forms available at the county clerk of the court office. A hearing is set within 30 days of the filing, with no attorneys allowed and just the 2 parents. However, though noble in its efforts, Kansas did not and does not still advertise the fact. In Missouri, an amendment was passed to RSMO 565.156, the child abduction law, making it a felony to deny the other parent their court-ordered access rights. Missouri did not make the fact known, but in cases where their father did become aware of it, county prosecutors in Missouri simply refused to enforce it, telling the fathers they just needed to go back to court. Of note on this, though not related to the grants, in Michigan, the custodial parent can lose their driver's license as a result of denying the other parent access to the children. However, this still requires a filing of a motion to enforce with the courts. Though in the 1980s and pretty much most of the 90s, enforcement of court-ordered visitation was not treated with much regard by the courts, that is now changing. Judges have become less patient with parents violating the access orders. Many judges are now putting offending parents, and yes, this includes mothers, in jail for showing contempt for their authority. However, the court does need evidence of clear violations of the orders to prevent their rulings from being appealed. This in mind, the parent whose rights are being violated needs to learn how to prepare for when they attempt to see their children, and how to collect an unimpeachable chain of evidence in showing that he or she is being denied access to the child or children.